Order, order. Welcome to this afternoon's session of the Foreign Affairs Committee, and thank you very much indeed for joining us. We have two witnesses on the first panel, and for no very good reason except that this is the way they appear on my screen, I'm going to ask Angela Mudukuti just to introduce herself very briefly first, and then Anthony Dworkin. Over to you, Ms. Mudukuti.
Good afternoon, Chair. Thank you for having me. My name is Angela Mudukuti, and I'm a human rights lawyer specialized in international criminal justice here in my personal capacity.
Thank you very much. Mr. Dworkin?
Thank you. Thank you for the invitation. I'm Anthony Dworkin. I'm a senior policy fellow at the European Council on Foreign Relations think tank based in London, and I work on a range of subjects connected with human rights, democracy, and international order, particularly working at the moment on multilateralism, but I've written also about the ICC not too long ago.
Thank you very much. As you know, this is part of an inquiry we're doing into multilateralism and the UK's role in multilateral organisations, and indeed the roles of many of these organisations in a very rapidly changing global environment. Could you perhaps, Mr. Dworkin, just introduce us by saying briefly what you think are the successes of the International Criminal Court?
Yes, absolutely. I mean, I think when you are thinking about the successes of the ICC, you have to look really at two levels. And one, I think, is really what the ICC represents. So the fact that we now have a permanent international court that has jurisdiction over the worst international crimes, that it has, you know, a kind of wide range of states that have joined as parties, and that it sort of exists at the, you know, in a way at the apex of what I would see as a whole kind of system of international justice, reaching down through other mechanisms, through states parties, and so on. So it's there as a kind of backstop and as a symbol that international justice and accountability is now a fixed element in the international system. And I think that is very important. When it comes to the specific actions and operations of the court itself, obviously, I think it's no secret that the record of the court is mixed, but there are some successes that one can point to. The conviction of Bosco Ntaganda, who's a warlord from the Democratic Republic of Congo with a very bloody record, convicted for, I think it was 18 counts of war crimes and crimes against humanity last year, you know, is a kind of symbol of what the court can achieve at its best in bringing accountability for serious international crimes. And you know, there are other decisions and actions that one could point to. But beyond that, I think part of the success of the court is in kind of spurring attention to accountability within states parties. So it's not only the cases that reach the court, but it's also the effect that getting parties to bring war crimes and crimes against humanity and genocide within their national jurisdictions, to act with the knowledge that the court is there as a backstop. I think all of that is as important as the specific case results that we've seen so far.
And do you think it has a dissuasive capacity as well, in the sense that people are now increasingly aware that this is a real possibility, that they might find themselves up before the ICC and therefore they think differently about their actions?
Well, I do, yes. I mean, there's been a certain amount of kind of scholarly debate about exactly how much of a deterrent effect the court has. And of course, it's always somewhat difficult to prove a negative. But I think, you know, to my mind, there are, plenty of instances where you can see that the countries are kind of conscious of either, you know, the danger that their nationals will face prosecution if they commit these crimes, or perhaps when they undertake investigations themselves, that they do so in a kind of more scrupulous way because they know that the court will be there watching them and potentially able to step in. So I think as part of that broader system that I discussed, I think one can see an impact in raising attention and raising the seriousness with which these kinds of crimes, are considered and addressed within many national jurisdictions.
Thank you very much. Ms. Mudukuti, you raised some concerns about this, and I was wondering if you could set out your views on bias that you've expressed in the past.
Absolutely, but before I do that, I would just like to add to the successes, because I think it's quite important when you look at the whole context. I think specifically, I would look at, for example, the Trust Fund for Victims, and I believe the United Kingdom has a representative on the Trust Fund for Victims board and has donated, I think, over 4 million euros since its inception. And that body has two mandates: reparations and the assistance program. The assistance program is what I'm going to focus on because I think that's particularly interesting. They've managed to reach, in Uganda and the DRC alone, over 400,000 individuals. And they assist with everything from prosthetic limbs, trauma-based counseling, educational support, income-generating activities, etc. And obviously done in consultation with parties on the ground. And the fact that this is something that doesn't require a conviction means that they can act quickly and assist affected communities as quickly as possible. And I think, although it's not perfect, I think it's something that's worth noting, because without the Rome Statute, there would be no Trust Fund for Victims. I'd also say that the victim participation model is particularly important, that victims can participate actively in the trials, not just as witnesses for the defense, not just as witnesses for the prosecution, but as participants themselves. And this, again, is important from a victim-centered perspective. And lastly, I would say that the court has also managed to make the world a smaller place for people who are wanted for egregious crimes. In 2015, I tried to have the former president of Sudan, Omar al-Bashir, arrested while he was in South Africa. And he arrived on a red carpet and had to scurry away like a thief in the night, which, quite an indignity for a head of state. And even though we did not succeed in our objective, which was to have him arrested and put on trial at the ICC, it was still important, again, from the victim perspective. It provides some element of hope.
Thank you very much. That is important context, and I'm grateful for you bringing it up. Could you please, though, touch on some of your accusations of bias that you've made towards the court? And I'd be very interested to hear your perspective on that.
Absolutely. First of all, I've never accused the court of bias. That's not
sorry.
I hold.
You're saying that there has been bias, that you've made allegations of bias around the court rather than to the court.
Yes, I think that there are people who've made accusations of bias against the court. I am not of the mind that the court is biased. In particular, people raise this with regard to the number of African situations that have come before the court. And the reason that people say this is because there are 12 countries currently under investigation at the ICC, and only 3 of them are not African. So that's Georgia, Afghanistan, and the Bangladesh-Myanmar situation. The rest are African cases, and the ones that are at trial phase are also African. But what we have here is 2 issues: perception versus reality. The perception in some corners is that the ICC is targeting Africa. The reality is somewhat different. I am not of the mind that the ICC is biased or targeting Africa, and I'll explain why. As you probably know, there are 3 ways in which a matter comes before the ICC. The first is the prosecutor can, of his or her own volition, initiate a process. The second is the United Nations Security Council referral. And the third is state referrals. You will see that 2 of the referrals are from the United Nations Security Council. So that's Darfur and Libya, African situations. I will come back to the Security Council and the complexities there because it plays into this bias discussion. 2 other situations, Kenya and Cote d'Ivoire, is where the prosecutor acted of his or her own volition. And 4 situations are self-referrals, where you have autonomous, independent African governments referring themselves to the ICC and seeking the ICC's intervention. That's the majority, is self-referrals. So this question of bias, I think, falls away when you look at the statistics. Still talking about numbers, 33 African states have signed and ratified the Rome Statute. 33 African states have subjected themselves to the jurisdiction of the court. So it's no surprise that there are a number of African situations because Africans have decided to be part of the Rome Statute system. This is the biggest regional block of signatories. There's no other region that has such high numbers when we look at signatories to the Rome Statute.
Why is it that so many African nations have done this? Why is it so many have decided that this court is appropriate for their needs?
I think that's a question you can't answer in a general sense. I think you'd have to look at each country specifically, which I don't think we have time to do today. But for some countries, for example, South Africa emerging out of apartheid, it was important to join international organizations and to show that they are serious about justice and accountability and moving forward in a way that shows a complete rejection of impunity. So every nation had different reasons, and being part of the new world order was quite a compelling one for many nations.
That's thank you very much indeed for that. And do you think that there's much that, sorry, Mr. Dawkin, forgive me, do you think that there's much chance that some African nations will be leaving the ICC, given what Ms. Mudukuti outlined?
Well, obviously there's one country that has left from Africa, another, the Philippines also. And Ms. Mudukuti probably would be following this more closely than me, but I believe that the issue is still at least live in South Africa. There's some possibility. But in general, I think, one can see that there was a sort of groundswell of concern and, a possible movement around the AU, the African Union, against the court. And I think that my sense is that that has somewhat subsided, and that this notion that the court was biased against Africa is perhaps less of a live issue and concern, as widely as it was a few years ago. Partly, I think that's because, as Ms. Mudukuti mentioned, there are now 3 investigations that are taking place outside Africa. And I think, in a way, some of the discussion and concern around the court has kind of moved on to other issues. So, it may always be that a country here or there will withdraw, but I think that the danger of the kind of legitimacy of the court being undermined by kind of large-scale withdrawals has receded. I don't see that as such an issue at the moment.
Ms. Mudukuti, do you see anybody following Burundi's example?
No, I think at the moment the momentum to withdraw has subsided, and it is true that in South Africa it is potentially still on the table, but other issues to tackle have meant that this has temporarily fallen off the radar, but that remains to be seen. But I don't think that we'll see this mass withdrawal, which of course 2 or 3 years ago was a serious concern.
Thank you. Chris, you wanted to come in.
Thank you, and thanks very much for joining us this afternoon. What do you think African countries hope to achieve by ratification of the Rome Statute?
Well, again, I'll begin by saying it's difficult to generalize. We're talking about a continent with many countries, but I will just point you to a few examples. For example, as I said, South Africa, this desire to be part of the New World Order. Also a recognition of the fact that you need to have justice on the domestic level and hopefully someday on a regional level and also at the international level. You'll find that there is no regional African court with criminal jurisdiction, and quite frankly does not exist. And so if you don't have justice on the domestic level, then you need a last resort, which is exactly what the International Criminal Court was designed to do. And I think there's also a sense of ownership in the sense that the Rome Statute needed signatories and without the African signatories, I think we wouldn't be talking about an established institution today. So I think that's also quite important to acknowledge the active participation of African states in ensuring that there is a court of last resort for their own people.
Right.
Sorry, can I just jump on that? Forgive me, Chris, before you go on to Mr. Dawkins. I think that's a very interesting point, that this is one of the essential building blocks of the certainly post-90s international order that has effectively been buttressed, reinforced, created in many ways by African nations. And I was just wondering, I'm going to come back to it, but is there an effect on the court? Has that affected the culture of the court, not just the jurisdiction?
Chair, could you be more specific about what you mean by affecting the culture of the court?
Well, has any organisation clearly focuses on areas in which its members or those who are particularly sensitive to it see interest. The World Health Organization recently has clearly had a rather greater focus on certain areas of illness than others. And, we've noticed that very specifically because that's where its funders and that's where its members have been interested. Is there an African element then to the ICC that has seen justice being done in different ways, has seen a level of interest in different things because, as you rightly say, this is one of the pillars of the international community that is, in many ways, much more African than many others?
I wouldn't say so, because the institution is a legal institution and they're guided by the confines of the Rome Statute. So the decisions that are made within compliance of the law. And so they follow the evidence, they follow where they legally have jurisdiction. So I wouldn't say that there's some sort of, as you described it, an African element that's influencing the institution.
Okay. Sorry, Chris, forgive me.
No, well, that was the same question to Mr. Dworkin, really.
Yeah, I mean, I think, I certainly wouldn't sort of point to any particular element of the court. In fact, I think, one of the things, and of course I do share the notion that any idea of a bias against Africa is much too simplistic. But there have been, I think, some ways in which the kind of operations of the court have been in some ways in tension with some of the views that, a number of African countries have espoused. And so, in that sense, I mean, I guess there are a couple of things that one can point to. First of all, it's in the nature of the court statute that there's enormous discretion granted to the prosecutor about the cases, the situations to take up and the speed at which the prosecutor moves through the different stages, from preliminary examination to investigation. And some of the preliminary examinations have taken an extremely long time. And I think, it has sometimes been said that particularly the first prosecutor, Luis Moreno Ocampo, that he was in some senses, treading rather cautiously around the political sensibilities of some of the larger and more powerful great powers in the world, the United States or Russia in particular. And so situations in which they had an interest, whether it was Afghanistan or Colombia, or Georgia, moved rather slowly. And some of the African situations seemed to move much more quickly. And so, in that sense, there was perhaps some sense that the court was still finding its feet as an international organization, a judicial organization, but situated in a world of power politics. And of course, there are considerations about, what makes an effective investigation that would lead to successful prosecutions and, taking account of certain realities. And that's been a kind of rather consistent tension in how the court operates. So in that respect, I think, rather than kind of reflecting African sensitivities, there was perhaps, a degree to which the court was seen to have, some element of greater, deference towards other countries outside Africa. Right. And then, a second issue, this is somewhat of a technicality, but there is this provision in the Rome Statute that allows investigations to be deferred for a year if the Security Council requests it. And there's sort of this assumption that if an investigation is getting in the way of peace and security, the Security Council might want to defer it for a year. And there have been a number of cases where some African organizations and African states have looked to, have thought that this would be appropriate to have a deferral because it might interfere with a possible peace process. I think this came up both in the case of Sudan and of Libya, I believe. And the Security Council has really not entertained that idea in those cases. And so there again, I think one can see that, rather than reflecting, what one might describe as African sensibilities, I think it's issues like this that gave rise to some of the tensions. But I think, as we can agree, most of these issues are somewhat receded now. But there still have been questions about the arrest of indicted heads of state and so on. So.
Yeah. Okay. Thank you.
Thanks very much, Bob. You wanted to come in, then I was going to go to Alicia and then to Claudia.
Thanks, Bob. And thanks to our guests for being here today. I agree with all the good that's been done by the ICC, and by asking a question that's slightly critical, it's not meant to be critical of the overall approach, which is clearly a major step forward for humanity. But it does seem to me that if you're a great state, you're judged by different rules, And if you're the client of a great state, you also judge, and I great inverted commas, a P5 member, you're judged by different rules. Some of the most appalling abuses of human rights and indeed war crimes have been the deliberate targeting of hospitals in Syria by the Russian Air Force. There's also been significant abuses of gay people in Chechnya, for example, and we know of a systematic oppression that's taking place in China in the Xinjiang province. And all these do raise I don't mean they make one cynical about the process, but I will see the ICC really working on a global basis when it's doing stuff in Syria and when it's worked out a means of tackling superpowers like China, or indeed former superpowers like the Russian Federation. And I'd just like great to get some comment on that from our two guests. Thank you.
Okay, well, I'll jump in, and then perhaps Mr. Mudukuti would like to add to that. So I think these are obviously serious gaps in the jurisdiction of the ICC, and when Syria in particular stands out probably as the conflict in the world where the highest number of atrocities have been committed that would fall within the subject matter jurisdiction of the court, and yet the court hasn't been able to get jurisdiction, and that's because it's not a court that has universal jurisdiction. It is a member, broadly speaking, a membership-based institution where states become a party to the statute, and that gives the court the jurisdiction to intervene. So I think, to my mind, it's really important to understand that that the ICC is a kind of it's a breakthrough in many respects, but it's also a body which does not represent the sort of dawning of the age of impunity. And the court was born at a time when there were great hopes, I think, in the period following the end of the Cold War, that the world was moving towards this kind of single order in which it would be the sort of the age of one set of values across the world, and a kind of gradual convergence perhaps around kind of broadly liberal democratic states. Clearly that hasn't happened. That's the background and context to, I'm sure, a lot of the discussions you're having about the challenges of multilateralism today. And it might have been hoped at one point that the ICC would move towards a court to which all states adhered, which had jurisdiction universally. But I think to expect it to do that is really to place unrealistic expectations on the court, which don't belong to the court itself. And the court's role is to hold accountable, individuals responsible for crimes in, either belonging to the nationals of countries that have signed up to the court, or when those crimes are committed on the territory of countries that have signed up to the court.
One can agree that a flaw in an otherwise, very decent process, but critical flaw is the more powerful the country that's doing the abuses, or the worse the abuses are in any particular country, the less likely people in that state are then to get justice. Is that fair?
I think there is a kind of perhaps a correlation, but there are different ways, I think, in which the influence of power on the operation of the court operates. So number one is many powerful states, among them China, Russia, and the United States, have not joined the court. And therefore, they can only be investigated when nationals of those countries are alleged to have committed crimes on the territory of member states, as we are seeing potentially in the Georgia investigation and with respect to the United States in Afghanistan. Then I would say a second element is that sometimes these states can kind of withhold their cooperation and even mobilize diplomatically, as the United States has done, to try and frustrate these investigations. And then the third element is the role of the Security Council, which is clearly the most great power influenced part of the international system. And it's a distinctive feature of the Rome Statute system that it allows the Security Council to refer situations to the court, even when those countries are not parties to the court, as it did in the case of Darfur and as it did in the case of Libya. And I think there are arguments both for and against these referrals. On the one hand, they do allow situations which would otherwise escape the court. And clearly Darfur, there were very serious crimes appear to have been committed there, to be brought within its jurisdiction. But they do introduce this very strong element of selectivity, because clearly China, Russia, and the United States have a veto in the Security Council. And so therefore, no referral will take place when it contravenes their interests. So I think there is also an argument to be made that referrals are not a tool that helps the credibility of the court, because they are so determined by great power politics.
Thank you very much. Alicia, you wanted to come in.
Thank you very much, Chair, and thank you to both of you for appearing today. I agree that generally it's desirable to prosecute cases in the countries where they occurred, but it can be very challenging in absence of robust legal systems, and particularly on matters of genocide. What is your view specifically on creating a new specialist court for matters relating to the persecution of the Yazidis, particularly since the ICC seems to be repeatedly blocked from doing so?
Do you want to take that?
Yeah, sure. I'll just briefly say that I think specialist courts had great momentum, I'd say, about 10 years ago, where there was a specialist court created for almost every single situation. And there have been questions about whether they've been cost effective enough, whether they've been effective enough. And in many minds, having an international criminal court that was a permanent institution was to alleviate the burden of having to create a special court. The situation with the Yazidis is not one I'm well versed enough to comment, but I think it is definitely worth one of the avenues that should be considered to make sure that something is done, and something is done sooner rather than later.
Thank you.
Yeah, if I can just add to that, I agree that there are advantages to having a sitting permanent court rather than creating an institution each time, but there have also been successful models for so-called hybrid tribunals, that is, international institutions that are based in the country with a mixture of international and domestic elements. The Sierra Leone Special Court is often held up as a successful example of that. But in the case of the Yazidis, it's not clear if that would be viable. There are a number of problems. I myself think it is really important and desirable to achieve accountability for the crimes against the Yazidis, but there are a number of issues that come up, and one of which, of course, is that's far from the only crimes that took place within that context. And would it be just a tribunal that sat in justice only of crimes against the Yazidis, or what about other state crimes that took place in the same area? So there are a lot of complications, but I do think that the crimes were serious enough that it would be worth pursuing some form of accountability. Yes.
Thank you, Chair.
Claudia, you wanted to come in. You're on mute.
I just, sorry, thank you, Chair. Just wanted to briefly come in and just thank our contributors for coming today and speaking to us, but also just to touch further on this issue of bias. And I hear what is being said about the concept of perception, but there is also a reality. And I just wonder what our panelists make of the comments by Chief Charles Taku from the International Justice Monitor when he speaks very clearly of selective views, or being selective, the ICC, or accusing the ICC of being selective, or the issue of political interference, or indeed the issue that in some of the cases, the issues of conflict that have been spoken of are often fueled by other state operators. For example, the UK isn't innocent in its supply of arms to African nations in periods of conflict. So I just wondered what you thought about those views as outlined by Chief Charles Taku of the International Justice Monitor.
Ms. Mudukuti,
Maybe
you addressed much of this initially. Would you like to pick it up again?
Yeah, sure, no problem. I mean, I'm not familiar with those exact comments that you've referenced, but generally speaking, I think this question of political bias, as I said earlier, the numbers and the reality is that that's not the case. The ICC is not targeting a specific region or group of people. I think everyone can agree that it is very important for any international institution to have a diverse geographical docket. There is no doubt about that. But nobody can dispute that the cases that the ICC has been involved in, crimes were committed and crimes that fell within the jurisdiction of the court were committed. So I think it's very easy to make a convenient argument and accuse the institution of these things, because then you draw into question its impartiality and thereby its credibility, which many people who have accused it of bias are seeking to do. And we see it a lot with political leaders who accuse the International Criminal Court of bias, African leaders from other states as well. And that's because there's ultimately a political agenda. When you speak to the victims of these crimes, it's a completely different story. They had no justice domestically, no justice regionally, and the ICC was the only option for them. So I think it's a question of who you're listening to and what their motives might be.
Well, I'm really talking about the International Justice Monitor. And what they have to say, and the fact that, for example, of 37 cases where there were charges, there were those 37 involved African countries, all 37. And I think what you've heard earlier is that there are clearly crimes committed in other parts of the world, and those aren't necessarily amongst the 37 or others being charged. I think I'm talking about what other international institutions are also saying, not what African politicians are saying, but what do you make of the International Justice Monitor?
Again, I haven't specifically read the comments that you were referring to, so I would need to do that to give you a fuller answer. But based on what you said, what I can say is that there is a recognition of this perception. And if you look now at the International Criminal Court's preliminary examinations, there are 9 countries under preliminary examination, and only 2 of them, Nigeria and Guinea, are African. The rest are outside of Africa. So I think, again, agreement that there needs to be a geographically diverse docket. But the institution is guided by law and by the confines of the Rome Statute and where they have jurisdiction.
Thank you. Thank you very much, Claudia. I'm very grateful. Bob, you wanted to come on a right to protect question, which builds, I think, on a couple of earlier points. Can you come in now? Yes,
thanks, Tom, and I'm hoping it does. Again, just to be slightly pejorative, just to get a reaction from both our witnesses, right to protect, very important. Countries like Russia have not liked it because it's seen to infringe on their sovereignty and maybe their spheres of influence. And it also seems to have taken a real knock in recent years with the Syrian war. Is right to protect effectively dead, or can it still be resuscitated? Can the policy of right to protect internationally can be resuscitated, or am I exaggerating its demise? Can we start with Angela this time? Thanks.
I think you might perhaps be exaggerating its demise. I think it's definitely taken a significant knock over the past few years, but I don't think that it's dead. And I think this is what speaks to the importance of accountability mechanisms such as a permanent court that tackles international criminal justice.
Yeah, I mean, I could just add to that quickly, if I may. First, I would say Russia's relationship to the responsibility to protect doctrine has been, somewhat complex, because when they actually intervened in Georgia, a number of years ago, they did try to justify their action under the responsibility to protect. So it's been rather more opportunistic, than simply opposing. But I suppose, those people who were responsible for developing and promoting this idea were keen to emphasize that it was, encompassed a range of measures, prevention, drawing international tension, and so on, and, not only military intervention. But there are always going to be cases where atrocities are taking place, and it's simply beyond the reach of the international community to do anything. And I think we're probably, many of us are a bit more chastened now than we were a few years ago about what is possible to achieve through military intervention. And I think if a state is strong enough, determined enough, and has international support, there may be limited options. And so in that sense, the goal of ending atrocities is an idealistic one, which is out of step with the reality of the world today. But it's there's still steps that can be taken in a number of instances, and it's important to keep international attention as well as domestic attention focused on doing what one can.
So it's going through an ebb rather than actually sort of being. It hasn't been quite written off yet, but clearly it's going through a situation different from one maybe a decade ago when there was more of an agenda to intervene. Is right to protect therefore dependent on superpowers, great powers, or powers with military force, or indeed the African Union, or and such like, being willing to intervene? To what extent does there need to be political will, or is that a statement of the obvious?
Well, I think there does, the success of action to end atrocities is going to depend on, mobilizing a broad international coalition. And I think that doesn't only go to the question of military intervention, which is, very much a last resort and always, entails complexities and, unexpected results. But in terms of, mobilizing international condemnation, mobilizing support to try and persuade governments, potentially implementing sanctions, all of these are a question both of political will and of how broad a coalition one can assemble. And so I think, it is a more challenging international environment now, I think, for these kinds of questions. And you can look at Xinjiang for a perfect example of that. But I still think it's important that we try to keep attention on these atrocities, to highlight that they are international crimes, and to see, what can be done in any situation to try and mitigate them.
Thank you very much. Royston, you wanted to come in.
Thank you, Chairman. Can I move on to the last year's comprehensive review that was advocated by the ICC president? What could be the possible repercussions of the findings of the independent review by the independent experts into the ICC? Either or both.
Okay, I'm happy to start with that. I think, so the independent expert review, the experts released their report this year, and it is far-reaching with recommendations on every aspect of the court, from governance to bullying and harassment to gender balance. And there's some very useful recommendations. And the idea is for the court to assess the recommendations and to see which ones are fit for implementation and how and by who. And the Assembly of States Parties now is currently involved in a process to develop a resolution for the implementation, or at least for the meaningful engagement and consideration of the recommendations produced by the experts. But what I will say for the expert report is that they touched on some very important issues that are crippling the institution at the moment, and one of them would be the gender imbalance. As of September last year, only 26% of women held any position above P5. The rest were held by men. So you can see the gender imbalance, which then of course affects issues of sexual harassment and how bullying is tackled within the institution. And the experts had some recommendations that will hopefully be taken under consideration by the respective organs of the court, as well as the Assembly of States Parties.
Yeah, if I can pick up, I mean, I would agree. I think this is a comprehensive, it's a very far-reaching report. Even the priority recommendations contain 76 points. So there's a lot there. And there are a lot of quite blunt and critical findings. In addition to the point about gender balance, I would say there's some, very striking findings about the kind of culture that obtained at the court more broadly. A culture of bullying, often you know, a number of other aspects of kind of unhealthy workplace culture, poor relations between different aspects of the court, some quite, you know, pointed findings about the efficiency of the judicial process, going on to, you know, a variety of issues about certain kinds of provisions within the statute itself. So there's a lot there to work with. And I think, you know, coming at a moment where I think there was increasing attention to the flaws and, you know, aspects that had not been successful of the court. You know, I think this really creates an opportunity now, having all of this spelled out in an extremely credible way, to really look at the court and try and modify its culture and processes, you know, improve some of the aspects that aren't working, focus international attention on it, and try and get it into a better place so that it can perform, you know, the extremely important function that it has. You know, some of the things that have happened, I mean, it's a new institution operating in a kind of complex environment with its mixture of civil and criminal law. You know, it's had a lot of kind of things to get to grips with. But I think this really is the moment now to focus in and use this opportunity to try and improve some of the functioning of the court and make it work better.
It must be the right thing to do to have your organisation peer reviewed or inspected by experts, and this is clearly the right thing to do, if nothing else, because of the independent experts' findings. But do you think that this makes the court more vulnerable to further criticism and perhaps disengagement by states?
I don't think so. The reason I say that is because the experts make it very clear that their job was not to tell us how fantastic the court is. Their job was to be constructively critical. And so when you use that as the starting point, you understand the significance of the institution and the importance of improving and building on what has already been achieved. And I think states parties who are vested in this process will recognize it as constructive engagement and hopefully nothing more. The report also makes it very clear that it is crucial to protect judicial and prosecutorial independence. And if that is maintained at the heart of possibly implementing these recommendations, then I don't think states will feel disenfranchised or will feel that they need to withdraw their support or abandon the court. I think maintaining the core principles upon which the court was built, acknowledging the successes, but engaging with areas of improvement, I think that's the purpose of the report, and I think they managed to do that in the way they presented their findings.
Anything else to add?
I completely agree with what's been said. I think that this is, you know, this wasn't coming at a moment where the court was perceived to be functioning well, and then along came someone, kind of a group of experts, you know, making arbitrary criticisms. This was an attempt to address, you know, a sense that the court wasn't functioning properly. These were points that had been made by a number of states, including, incidentally, a very kind of strong and influential address by the UK legal advisor a couple of years ago at the Assembly of States Parties, which was quite widely noted. And, you know, this is a really responsible attempt to get to grips with the problems of an institution that, you know, nevertheless is recognized to be playing an essential and invaluable role. And I think it should really be seen as an opportunity for improvement, which I believe it does represent.
Lovely. Thank you both very much for your answers. Thank you, Chairman.
Thank you. Can I come back, perhaps, Ms. Mudukuti, to some more parochial matters, which is the UK's influence on the ICC? What influence does the UK have? Is it positive? Is it negative? How do you see it?
The best way to answer that question is really for me to point you to some of the practical things, the positive and the negative things that the UK has done in the past with the International Criminal Court. And the first one I would say is funding. The UK has provided a lot of funding, particularly to the Trust Fund for Victims. But of late, we've seen the United Kingdom align with states who are pushing for what they call zero nominal growth. So basically minor budgetary increases that don't even take into account inflation in the host state, the Netherlands. And so other states have been more constructive and perhaps more progressive on this issue and have said that rather we should look at what the court's actual financial needs are and determine the budget based on that. So, for example, Argentina, Belgium, Liechtenstein, Luxembourg, Sweden, and the Netherlands are some of the countries who've taken a more progressive stance on the budget. So that's perhaps something to consider going forward as well. The United Kingdom has also shown political and diplomatic support for the court in the face of aggression from non-states parties and sanctions from non-states parties as well. The United Kingdom joined a letter of 67 states parties confirming its unwavering support for the ICC. And again, in November this year, the United Kingdom, on the occasion of the ICC report to the UN General Assembly, joined a statement with 74 other states showing support for the court. So this kind of diplomatic and political support has proved invaluable in the past. The United Kingdom also has been proactive as far as voluntary agreements with the ICC go. For example, relocation of witnesses, release and provisional release of detainees. I believe you actually enforced a custodial sentence for Mr. Al-Mahdi, who comes from the situation in Mali. He was convicted and the UK concluded a voluntary agreement to that respect. So these are things that have been practically useful and of value. And then I think to direct your efforts, one should take a look at the 2019 Assembly of States Parties resolution on strengthening the court. And that resolution calls for promoting the universality of the Rome Statute, for example. Also encouraging implementing legislation. Perhaps the UK, as part of the Commonwealth, could play some role in that. Better cooperation between the United Nations Security Council and the ICC. The UK, being a member of both, is well placed, perhaps. So these are the things that I would point you to as far as positive and negative influences.
Thank you very much indeed. And perhaps, Mr. Dawkin, you might have some views to what the FCDO, as it now is, should be doing to strengthen the ICC.
Well, I very much agree with what Ms. Mudukuti said. I mean, I think that in the case of the UK and the FCDO particularly, the UK is, has international influence as a kind of, very credible country in the field of international law and international justice. There's a very strong tradition of international law in this country. Many influential thinkers and writers in the subject are, have come from here. I think the UK has a kind of, thought leadership role within the ICC community, within the Assembly of States Parties, in terms of perhaps leading, some reflection on some of the issues that came out of the independent expert report, and perhaps also in taking further some reflection on some of the points about the operation of the court, issues like the notion of complementarity and how that should play out in practice. What situations should be left to domestic processes and when the court should step in. This unresolved question of the interests of justice and how much weight the prosecutor should give to that. So these are all issues on which I think a British voice, might carry some influence. And then the point about the UK's role in the Security Council, I think, is an important one, because obviously the UK is alone with France as being among the permanent members that's also a state party to the Rome Statute. And so I think that relationship between the court and the Security Council has been a complex one, and the UK is, I think, well placed to lead in thinking through some of how that relationship could work better in the future.
Thank you very much. And is there any actual change needed for the ICC, or is it just a case of positively influencing directions, do you think?
Well, I would say, I think that, I'm not, I don't particularly think, obviously there's some questions that would involve, redrawing the statute and so on. But for me, the most important changes, they are changes, I think, changes to the processes of the court, changes to the culture within the court. These are all things that are, I think, would be really important. One of the things that has been, particularly damaging to the court in recent years has been a series of unsuccessful prosecutions of high-profile figures, former presidents, current presidents in some cases. And there've been a string of incidents in which these cases were pursued and then more or less either collapsed or led to acquittals or were overturned on appeal. And so I think the question of how cases are developed, how the evidence is assembled, those kinds of aspects of the processes of the court really need to be improved. And then I think that, this very difficult question about how the court selects what priorities it's going to have, how much weight and at what stage it gives to the prospects of success is a complicated question for the court, because if it ignores the prospects of having a successful case, then you're likely to see a lot of cases which don't succeed. And yet if you only go for the cases which seem easiest, a lot of times you're going to be letting the most powerful actors off the hook. And so there's quite a delicate navigation. And I think the prosecutor has kind of laid out this strategy of, opening investigations based on the level of the crimes, but then perhaps pursuing, actual prosecution of cases based on prospects for success. And that seems like a promising way forward. But, all of these, so I think there's a range of things from the, the strategies of the prosecutor to the processes of the court, to the interpretation of some of the provisions of the Charter and the relationship with other international bodies. That's quite a wide agenda, most of which is there in the independent experts report, and which doesn't involve revising the statute. But, these are nevertheless, I would say, changes, in how the court works rather than mere tweaks.
Chair, if I can just add to that, I'm going to say something that really falls squarely at the feet of the Assembly of States Parties, given that it is an election year this year, and given that in 2019 at the Assembly of States Parties, the UK was one of the countries that called for merit-based elections at the ICC. And this is hugely important because what we see at the ICC and many international institutions for that matter is vote trading. So instead of voting on the basis of merit, states exchange votes. You support me here, I'll support you at the Security Council. And none of that is actually going to give us the best possible candidates to be on the bench for the ICC. So this is something that needs to change, and states parties are solely responsible for the development of this culture and therefore the termination of this culture.
Thank you. I think that's a very important point, and we've certainly had experience of it in other elections as well. That's not new to this case. Alicia, you wanted to come in.
Thank you, Chair. Mr. Dawkin, President Trump placed sanctions on ICC prosecutor Fatou Bensouda and other officials, freezing their assets, blocking their entrance to the US because they wanted to investigate whether US soldiers have committed war crimes in Afghanistan. To what extent does this sort of activity occur commonly? Have you got any other examples? And have other US and Russian actions recently had a detrimental impact on the ability of the ICC court to function effectively? And what other countries would you say are particularly hostile to the ICC?
Well, I would say that, it is routine and probably unsurprising that countries which are not party to the court are unwilling to cooperate in its activities, and they're particularly unwilling to cooperate in those activities when they affect nationals of that country. So Russia in Georgia, for instance, or Israel perhaps in the Palestine case, if that goes forward, or the United States in the case of Afghanistan. What is really, to my mind, unique about the United States is the way that, at certain moments, it's moved beyond that to what could be described as a campaign of active measures to undermine the court. And I think that really stands out internationally. And we saw a little bit of that in the Bush administration, George W. Bush, just after the court was set up, when the United States took various steps to try and agree bilateral, agreements with different countries using its diplomatic way to prevent their nationals being handed over to the court under any circumstances and so on. But it's really been ramped up under President Trump. And, this idea of placing sanctions designed for use against terrorists and others threatening US national security, against officials of an international body devoted to promoting the rule of law, is kind of quite extraordinary. So, I think, now obviously we're looking at a change of administration in the United States, and it'll be interesting to see what the Biden administration does on this question. I expect and hope that they will withdraw the sanctions quite quickly, but I think they won't, they will go back to a policy of non-cooperation, I expect, with respect to the potential investigation of US actions. But perhaps they'll pursue a bit more a course of engagement with the court to try and, there are a number of arguments that they can make, that these crimes don't rise to the threshold of gravity that was involved, or perhaps that they've addressed them at home. These are, arguments that can be made, and to my mind, they don't necessarily succeed. But I think it'll be some kind of combination of engagement and perhaps a degree of non-cooperation. But this, I think broadly they will support the action of the court in general and be sympathetic to it. So this campaign of trying to undermine the court as a body, I think, will stop.
Thank you.
Thank you very much. Alicia, did you want to finish?
No, that's all from me. Thank you.
Well, in that case, can I thank both of our panelists enormously? I must say I found that extremely informative, and I'm extremely grateful for your insights, particularly your perspective on the challenging nature of how we address regional as well as multinational areas. Thank you very much indeed. We're now going to go on to the second panel. Now I can see Sir Howard, forgive me. Is Mr. Lewis here? Because what we'll do, if it's all right, is we'll do a straight handover rather than closing the session and starting again. So I'm going to say thank you very much to Ms. Mudukuti and to Mr. Dworkin. And I think they've now been silenced. Forgive me, it's a rather brutal process. I think they've now been silenced, and we'll now go on to our new witnesses. Right, and just in exactly the same way as we did for the first two witnesses, I'd be very grateful if you would both just give a sort of one-line introduction of yourselves for the record. And for no other reason than you are on my left, on my screen, probably not on anybody else's, but on mine. Mr. Lewis, you first, and then Sir Howard.
Yes, my name's Peter Lewis. I'm the Registrar of the International Criminal Court.
Thank you, Sir Howard.
Hello, it's Howard Morrison. I'm the President of the Appeals Division of the International Criminal Court, having been a trial judge previously at the Yugoslav Tribunal.
Thank you very much indeed, both of you. I'm extremely grateful for you giving up an afternoon to help us here today. Now, we've heard about the importance of making the International Criminal Court as representative as possible. And I was particularly struck by Ms. Mudukuti's point about the size of Africa's contribution to it. And I was wondering, what could the UK government do to contribute towards a goal of greater representation on the court? Perhaps, Mr. Lewis, you'd like to start.
Yes, thank you. Thank you very much. I mean, just to give you some background, of course, we have 4 judges from Africa. Of the 18 judges we've got, of the staff we've got in the court, you would expect, in view of the representation from African states at the court, we would have about 13% of the staff would be from Africa. In fact, we do slightly better than that at 16%. But that overall figure hides a lot of imbalances, and we've got a number of states where we've got no representation from African states here at the court. Now, I mean, just to be very practical about these issues, of course, we advertise for posts in the way everybody else does, but there is an advantage one has in applying for posts at the court, which is if you've worked in an international organization before as an intern or as a visiting professional. And that enables you to explain to a recruitment panel that you actually can do more than just work in a domestic situation, you can work internationally. Now, one of the problems we've got and one of the challenges we've got from Africa and some other places of the world is some of the poorer countries, you haven't got enough students who've got the private means to come and enjoy our internship programs. Now, the court, the Assembly of States parties made a decision a few years ago that they would not fund internships at the court. They had to be funded by voluntary contributions. Indeed, we have got a voluntary fund, but we're not getting enough interns from African states through the court. We're not getting enough visiting professionals. These are people, visiting professionals, experienced professionals who would like to take a sabbatical and perhaps come to the court. All that has to be self-funded at the moment, because that's particularly difficult for poor countries. So one of the issues that I really quite keen that we do is find a way to encourage staff, potential staff, or potential students from underrepresented states to come to the court. And I think the UK could help, perhaps through the Commonwealth, in helping us do something of that nature. As you know, the Commonwealth does have schemes where it encourages students to work at international organizations and does some sort of cross-funding to help make that happen. So I think there are a number of things we can do, but and perhaps I can just say this as well. One of the great things about the interns and these visiting professionals is not simply that they end up here as employees, as important as that is, or become judges for the future, but you do create a community, particularly in the academic community, of people who know the court, understand it, and can support it, stimulate debate about it, be critical of it. So it has a wider benefit. So I think there is something that can be done, but the gap at the moment to me is what can we do to stimulate young people to spend some time here as part of their professional development? Thank you.
Thank you, Sir Howard.
Well, I'd agree with everything that Peter said. This always sounds a bit mealy-mouthed, but I have to make it plain as a sitting judge that the views I give are mine alone. They're not ICC policy, or certainly not views of any other judge, and there may be stuff I can't comment on because I am still a sitting judge. But having made that disclaimer, I can draw upon 23 years of active involvement in international criminal and humanitarian law, been defence counsel and judge in 4 different international tribunals at both the trial and appellate level. And in doing that, specifically in reference to Africa, I have come across an enormous number of extremely talented African lawyers and judges. And they are an essential part of the international legal community. There is no two ways about it. We've been blessed with some very, very good African judges, and more needs to be done, as Peter says, to be able to encourage people from poorer countries to come to the court. And it is a pity that internships are not funded, and I think looking at that in isolation might be a very useful thing for the countries which can afford to do so. And I would certainly advocate that the UK think about that. It's something, without talented young people coming into the institution at the bottom end, it's very difficult for it to grow.
Thank you very much. Alicia, you wanted to come in.
Thank you very much, Mr. Chairman. This is going back to one of the topics we looked at in the last group in terms of obstructionist actions by non-party states and the kind of detrimental impact they have on the court's activities. What processes are open to the ICC in the Assembly of State Parties and the UN Security Council in the case of a state refusing to cooperate with an arrest warrant or investigation?
Right. Is that one for Peter or for me?
Please do, either of you, whoever's most passionate about the subject, please do.
Well, yes, a certain amount of passion. What the UN Security Council can do is not restrict or bar UN funding for investigations and prosecutions, and not to seek to limit the jurisdiction of the ICC over persons relevant to the situation. They could establish a process to consider whether to impose targeted sanctions on individuals wanted by the ICC, because the ICC has no police force. We can't go out and arrest people. The ICC, as must have been said, depends entirely upon voluntary cooperation, both within and without the ASP, and particularly from a powerful body like the Security Council. It could give explicit mandates to UN peacekeeping enforcement and peace-building missions in territories that are also ICC situations to cooperate with the ICC. The Yugoslav and Rwanda tribunals, I was defense counsel at both and a judge at the Yugoslav tribunal. Because it was a UN Security Council mandated tribunal, it had Chapter 7 powers. And under Chapter 7 powers, you could ask for, or you could demand cooperation, and you got it, and we did. I was a judge in the Radovan Karadzic case, where we frequently asked states to cooperate, and they did. I can't remember a single state who didn't. But we don't have any police, and whilst the Yugoslav tribunal in particular had the active cooperation of UN peacekeeping forces on the ground in the Balkans, the ICC doesn't have that. But there's no reason why the UN couldn't mandate forces in those territories to cooperate with the ICC. They could also extend the mandate of the informal working group on international tribunals, which they have, to include the ICC to provide more structured and better informed discussions on ICC matters. The UN Security Council has an enormous power, but as has been mentioned, only the UK and France are permanent members, and there has been active or passive resistance by some other members.
Thank you, Mr. Lewis.
Well, I think I would, one of the things I would add to what Sir Howard has just said, all of which I agree with, but also as well, I think we need to, for many of the countries that we're dealing with, whereas as Sir Howard says, we're relying on voluntary cooperation from them, often they're making a hard decision to assist us. It's a political price to be paid, or there's a security price to be paid for them to make a decision to help us. And one of the things, speaking to a number of ambassadors, is what we can do, or what can be done collectively by states parties to make that choice a bit easier for people. So, for example, the example that's often given to me is, in some of the situations we're working in, if all the aid donors got behind some of these issues and said, look, we want to work with you. We're not making aid conditional on, a particular cooperation request, but it really is important to us, if we want to keep engaging with you, that you do cooperate on issues like this, because peace and justice are really important to us. So it's what we can do to build this strong coalition to support people when they're making these difficult decisions, as well as trying to put some more hard force on them at the same time. I think both are required.
And so just to follow up, Chair, so in terms of the Office of the Prosecutor on its own, if we have the UN frozen in deadlock, as it currently is, or being undermined by those who want to stop certain things being investigated, is there any situation in which the Office of the Prosecutor could rule in a situation that a non-ratifying state was contravening international law or undertaking arbitrary detention or anything like that without a formal referral? Or are they just unable to act in any way kind of independently?
Well, as I think previous speakers have said, the mandate the prosecutor has is one set by the Rome Statute, which is basically treaty-based, for the countries that are members of it, where she's got, more direct engagement with the states parties. But then for states outside that, it's in respect of matters that have been referred to her by the Security Council. On other countries outside those two basic referral or treaty-based mechanisms, the court hasn't got a standing to discuss matters that are taking place outside that context.
And one more, Chair, if I may, before we move on to the next area. In terms of kind of hostile interference and efforts to undermine the integrity of the ICC, the operations of the ICC, obviously we talked earlier about I guess what some would call the usual ragtag vote bartering, which shouldn't be taking place. What concerns do you have specifically about the resilience of the ICC to hostile influence, and what sorts of hostile efforts are underway by member states and non-member states to prevent the ICC from being able to function effectively that you've seen?
Well, if I may just start on that, I mean, we have just faced the most extraordinary situation over the last 6 months with being subject to US sanctions. And I'm afraid if you've ever been on the receiving end of that, the power of UN sanctions is phenomenal, utterly phenomenal. And part of that is because commercial institutions voluntarily comply with the sanctions regime when they don't have to. So we faced the real prospect during this year of not having banking. Simple as that. As simple as that. And even with the enormous support we had from the host state here in the Netherlands, we have secured one bank that was willing to continue to do business with us and any of our staff who were designated. And we've had problems with other circumstances. So I'm afraid the enormous power that we've been subject to, thank God we managed to stay in business and keep working, not least because of the help of so many of our states who supported us. But like previous speakers have said, I really hope that this matter will be reversed sometime in the new year.
Thank you. And to you, Sir Howard, as well as any specific requests you would have of how the UK can better support the resilience and integrity and independence of the ICC.
Well, it has, as been said, a huge reputation already for promoting the rule of law and for supporting the rule of law, not only, of course, in the UK, but worldwide. So that reputational value means that whatever the UK does or says is going to be taken seriously by a great number of people. We mustn't underestimate that. But I do want to say, because he wouldn't say it himself, that although in terms of the recent sanctions, host state and others have done a lot of good work, Peter Lewis has done a fantastic job of maintaining the position of the ICC in the face of real opposition. That needs to be said. What the UK could do as a member of the ASP could invite or ask at least the ASP to routinely respond to findings of non-cooperation that have been made, in particular by asking both the UN Security Council and indeed the General Assembly to take appropriate measures, and in particular open letters reminding states not only of their general obligations under the Rome Statute, but also of the specific consequences that might arise from their discrete failure to cooperate might be helpful. And the UNSC has an awful lot of power, including sanction power against relevant states. I know that's a last resort, but in some cases, last resort is necessary.
Thank you both. Thank you, Chair.
Thank you very much. Claudia, you wanted to join on this question and move on?
Not particularly, unless you want me to ask a particular question. Okay. You thought I was waving.
I thought you were waving, forgive me, yes. No, okay. The recent independent experts report was critical over a number of areas, not least the culture. What damage have these done to the image of the court?
Well, that's difficult to say as much from the inside as it might be from the outside. I mean, obviously, it doesn't do the image of any institution any good to have those sort of findings made. I have to say I have a lot of sympathy with the position. A couple of years ago, I went to a staff meeting. In fact, I was the only judge who went to the staff meeting, where I was shocked and disappointed at the number of people who said they were subject to not so much sexual harassment, but sort of bullying and gaslighting in the workplace. That was a real eye-opener for me, and I communicated that to the other judges. Very difficult for the judges to do anything about it, because this devolves down to, as it were, the ladder of seniority in individual departments, and requires active management on the part of the seniors. But having seen that reaction from the staff at the staff meeting, it didn't come as any surprise to me that it was part of the experts' report. It isn't, some of the press reports that came out afterwards were grossly exaggerating, as if it was happening everywhere and at all time, but that it happens at all is unacceptable. And if it goes down to the level of sexual harassment, it's particularly unacceptable. People forget that that's not simply a thing to be very critical of. It can amount to a criminal offence.
Thank you. Mr. Lewis, did you have any views?
Yes, I mean, the first thing I want to say is that the court did, the principals of the court did welcome this review. If an organisation is genuinely to move forward, it has to submit itself regularly to outside scrutiny and to really have everything looked at. Now, there's a price that comes with that sometimes those reviews and reports are going to tell you things that are difficult for you. And this is certainly no exception, but it's really important that we confront these issues. This was a really, I think, very experienced panel of individuals. They did their job, I think, very well. They spoke to so many members of staff, and they've given us a clear message about how serious this is for us and what we need to do to fix it. So part of this review process, if we're going to improve, is that we look ourselves hard in the mirror, and they've certainly forced us to do that, and that's right and proper. Thank you.
And what measures are you taking to address this?
Well, there's a number of things we're doing, and I mean, I think one of the issues I would say is that I think one of the challenges to the court is, and this is fundamentally recognised in the review, we've got the same problems that every other organisation has in the world, but our speed and the governance, the speed of the governance ability to respond to that is very slow. And that is one of the fundamental problems. So in facing the issues that we've had, the court itself has embarked on a number of issues that I'm convinced will make a difference, a positive difference. But it's taken us a very long time to grind through the bureaucracy. So a simple issue would be, what modern organizations do now is, for example, one of the many things they do is have a focal point. There's a focal point for women, focal point for gender, somebody within the organization who becomes the place, the repository of knowledge where people can feel they can go to for advice on individual issues, but more importantly, who can help the organization challenge itself by saying, what are you doing on your recruitments that means you've only got so many, senior women? Now, the court recognized it needed such a post. It was only, I think, the week before last, that finally we ground through all the bureaucracy to make that decision and agree it. So what we need to get out and respond to this is the things that we've been talking about, that we actually get on and do them. We need a new set of policies, up-to-date policies on harassment and discipline. We're using the first generation of UN policies. We need to have the most contemporaneous ones. The process we go through is very slow. So one of the things I hope is that will come out of this independent expert review is that we speed up the governance of the organization, cut through some of this bureaucracy so we can respond quickly decisively to the issues that are there. Thank you.
Thank you. Sorry. Of course.
Can I just support that? Peter said, when I was at the bar, I was a member of the Race Relations and Equal Opportunities Committee of the Bar Council. And it was very interesting when we found out what was going wrong and publicised it, how quickly some of it turned round. Perhaps not as quick as it could have done, but having these commissions, having these committees, bringing stuff out into the open is extraordinarily valuable.
Thank you very much. I'm grateful to hear all that. Neil, you wanted to come in.
Thanks, Chair. The first panel was very complimentary about the UK diplomatic and political support for the ICC, and I wonder if you wanted to add anything to that, in particular, Mr. Lewis, in light of the experience you just touched on, and whether you wanted to add if there was anything else the UK could have been doing to support you through what has obviously been a very destabilising time. And then more widely for both of you, if you could say where the UK has influence at the ICC, and I ask that mindful of our candidate not making the shortlist for the new prosecuting judge position earlier this year.
I mean, just on the UK's position, it's already been said. The UK has been enormously influential in the court in the process that led to the Rome Statute, where it was seen as playing a particularly significant role in shifting opinion about the court, and has, I think, maintained that very strong leadership position throughout. It's given us a number of great judges, which people have talked about is really important. You know, we've got a really senior member of the Trust Fund for Victims, hugely important, an influential post. It provides expertise. On the Committee of Budget and Finance, which is, the sort of oversight mechanism for the states parties. There's Britain has sent significant senior people. It has just provided another very influential expert when we've looked at some subjects like remuneration. So Britain does an awful lot and is very strong with us on cooperation as well. It's already been mentioned, and including issues that it does. It's played a very significant role in the last 12 months in the Central African Republic, where a donation from the United Kingdom has helped us do the outreach to the victims of the offences there. So in all sorts of ways, the UK is playing a really significant part. And it did at the Assembly of States Parties, it was one of the first voices that said, come on, if we're serious about this institution and our support for it, it needs to change. If we're serious in our support, we need to see more from this organisation, and we want to start that process. It hosted a conference in London before the independent expert review was started to start thinking about that, and that sort of thought leadership is really important, and it needs to continue. That's, I think, more of the same is, I think, really the underlying message. Thank you.
Yeah.
Thank you very much. Neil, do you want to go?
I thought Sir Howard was trying to come in.
Oh, sorry. Go.
Yeah, well, let me talk about my personal experience first. I have had huge help from FCO or FCDO legal advisors throughout my time in international law. I mean, there's real expertise there, and there's a lot of strenuous effort put in. When I was up for election to the ICC, the number of people working very hard on my behalf was extraordinary. And after I was elected, I wrote a letter describing it to the then Foreign Secretary as diplomatic excellence, and I was not exaggerating. It really was. And it's continued ever since through contact through the British Embassy in The Hague with the legal advisors there. So that's been very important to me personally, but you see it in a wider aspect. The UK is honest about the people that it puts forward for jobs, in that they meet the job specifications. And I've said it many times that the ICC is not a human rights institute, although we apply human rights principles, and it's not a PhD factory, it's a court. And it's a senior criminal court. And to have people in a senior criminal court, you need at the top end, especially in the judiciary, people with strong criminal court backgrounds who can absorb international law, all the better if they've got both before they start. And the UK does that, and it has it not simply at the ICC, but it's true of the ICJ, it was true of the Yugoslav Tribunal, it was true of the European Court of Human Rights. So I think there's a lot to take genuine pride in that respect, that the people that are put forward, and it sounds horribly like blowing my own trumpet, and I don't mean to, but some of my fellow UK judges have been really extraordinarily good. And the UK takes those responsibilities extremely seriously, and more importantly is seen to do so. And we talk about the horse trading that goes on for judicial elections. I mean, I've been advocating for a long time that that procedure should change, and there should be an independent international judicial commission. I said as much to the experts when I was interviewed for the report. A lot of reluctance, but it wouldn't be a difficult thing to set up, and the ASP could be involved in that. And it would perhaps help to do away with some of the undoubted horse trading that goes on. Everything in a court of this nature needs to be merit-based.
And Ms. Liz, is there anything else you want to add to that? And you know, is it that the FCDO needs to invest more time in an effort into making that change from the horse trading, as Sahoud's outlined, to the merit-based approach that I think Angela Mudukuti was talking to earlier?
Well, I think there has been a positive development along that on that direction. I mean, it's not as far as perhaps the ultimate that Sahoud has talked about, which would be the acme of this. But the process for considering the judicial candidates this year, I think, has been more rigorous than before. The panel that considered that was led by a very distinguished UK judge, former judge at the ICC, Sir Adrian Fulford. And, you know, I think there's been more interest from the states in the analysis that has taken place this time. So I think that there has been a step forward, at least it seems to me, in that with more rigor applied this time round. But of course, it still goes to an election, and it's at that stage that things move on. But at least there's been, you know, the panel that Sir Adrian Fulford has, you know, led this time, I think, has done a very thorough job of assessing the credibility of the candidates, and it's being talked about. That's the other thing I've picked up. It's being talked about more because that process is seen as being robust.
Yeah, I can certainly agree with that, and Sir Adrian has done a very good job, and it's changed notably in the last 2 or 3 election cycles for the better.
Thank you very much. Claudia, did you want to come in and add to this?
Yes, I do, if I can unmute myself. Thank you, Chair. I just wanted to wonder, because you've answered quite extensively the questions, particularly in light that there is an appointment due, how people get sort of, how the process of selection in your respective, and what happened in your respective roles when you were selected. But I want to know if you could draw on any examples of the appointment of officials being used as tools for states to exert influence for self-interested purposes.
Well, I genuinely cannot. It's not that I don't want to. I really can't think of an occasion when that's happened. I'm not saying it hasn't happened. It's simply not something that's come to my attention, but there's always going to be a risk of that. It's all of these processes involve a measure of self-interest. Of course, everybody wants to get their own judge or a prosecutor from their own jurisdiction in. There's a sense of pride in that and a sense of achievement, and there's nothing wrong with that. But if it's done for, as it were, underhand purposes, then of course everything is wrong with it. But it's not something I've personally can talk to.
Okay, and I don't know
Sorry, we've lost you there, Claudia. You've gone on to mute.
Sorry, I'm not sure if Peter wanted to come in.
No, well, only to add to just agree with what Sir Howard has said. I haven't seen that, and I mean, one of the things I would just say is that the posts in these international organisations, if the court is anything to go by, these senior elected posts, you're under enormous scrutiny, and not just from the states parties, actually, but from civil society, the NGOs, who play a much greater role in the scrutiny of an international organisation than perhaps they do in a domestic organisation. So people who are elected are subject to real scrutiny, all their decisions, how they act, how they conduct themselves. So I've always hoped that degree of scrutiny is one of the protections, if you like, from somebody being put in to to sabotage an organisation or move it in a particular way.
Yeah.
That's...
If I can just add to that by saying the Coalition for the International Criminal Court, which has hundreds of NGOs attached to it, is a very powerful tool and very useful and should not be underestimated.
Thank you for that. Chair, if I could just ask a wider question about UK influence more generally in relation to the International Criminal Court, and that is, do you think there are any domestic or international issues that could undermine or have the potential to undermine the UK's influence or standing in relation to the ICC?
Okay. Well, perhaps Peter would like to go first on that.
Well, I mean, this may seem an odd way of answering that question, but it's from my experience of being here is where the UK's influence comes from. Howard has already, I think, referred to this. A lot of it is, the history of the UK, the strength of its public service, including its judges, the process that people have gone through. All those things are admired. Its history and its long history of strength of the rule of law is hugely important. We have educated, the UK has educated so many of the people, I mean, not just obviously the Brits, but people from all over the world. The university sector is so strong, and people, particularly in international law, all come, if they've been through a British university, which they often have, they've got such affection and regard for the UK. And it's these issues that are, I think, the bedrocks upon which our reputation are based. And, so it's those big fundamental things rather than, from what I've seen, rather than any issues about individual decisions. It's those fundamental bedrocks that seems to me to drive the reputation and therefore the influence. Thank you.
Yeah,
I wonder if Sir Howard might delve a bit deeper into offering some critique. And we know, obviously we know that the UK has some significant and powerful contributions to make. But what about the issues that have the potential to, that undermine or have the potential to undermine its influence?
Well, it would take an awful lot to undermine its influence, because as Peter says, and you can, this is the 75th anniversary of Nuremberg, and I think the UK's reputation in terms of international, modern international criminal and humanitarian law can be traced back to its involvement at Nuremberg, not least by having the presiding judge and prosecutors there. And that's sort of been carried forward. Of course, you're always going to get individuals either in a social comment or political comment who are going to say things which may jar the international community. But I think people are bigger than that. They understand that those are individual positions. And if we're looking at the UK's position overall, and I think that's what matters as far as the UK is concerned, then I frankly, I don't anticipate that there is anything currently going on to seriously worry about. There are side winds that blow inevitably, and if a political or judicial decision that's made in the UK somehow seems to chip away at due process, there are going to be plenty of academic comments about that. But at the end of the day, as Peter says, there is this bedrock which supports the UK, and I don't think that, but that certainly shouldn't be underestimated. We just need to be very cautious. It is a reputation which needs to be enhanced and not put at risk.
Okay, thank you. Thank you, Chair. I think I've pushed as much as I can.
Thank you very much. Could we come to a last question, if I may, which is, Alicia, you wanted to come in.
Thank you, Chair, and thank you both again. Starting with you, Sir Howard, stopping a genocide being committed by a superpower is an enormously difficult challenge, and one that many of us are currently struggling with. A coalition of the Uyghur have called for an investigation into whether the Chinese Communist Party's actions in Xinjiang constitute genocide, or whether they constitute crimes against humanity. My personal view is that forced industrialized sterilization of women, forced abortions is at the very minimum a sign of an intent to commit genocide. But it'd be really helpful to have your professional and personal view as to how we reach the definition of genocide. What options are there to secure a declaration of genocide? Because obviously it has to be an international court, not a domestic court. And what would be the likely consequences of an ICC ruling that activities in Xinjiang did constitute a genocide?
Well, I'm looking at genocide in general rather than particular, and because I am a serving judge, I'm not going to concentrate on a particular allegation or a particular case. But the definition of genocide applies across the board. There is the Genocide Convention. Let's make it plain. First of all, genocide is a crime against humanity. It's distinguishable from other crimes against humanity because of the egregious nature of genocide and because it requires a specific intent. You need to intend to destroy in whole or in part a national, ethnic, racial or religious group. And that includes killing, causing serious harm, deliberately inflicting conditions of life that bring about physical construction in whole or in part, imposing measures intended to prevent births within a group, which may be more aligned to the way you were talking earlier, forcibly transferring children from one group to another. One of the things is that the victims of any given series of offences historically would rather like it to be categorised as a genocide because that seems to make people sit up and take more notice of it. But there is a danger in watering down genocide, and you certainly need that specific intent, which can be inferred from subsequent actions or from speeches or acts that are made in respect of the genocide. At the moment, there's a sort of some academic debate between whether or not the specific intent should be reserved to those masterminds who are in charge of the genocide, that lesser operatives or apparatchiks, as it were, simply should have knowledge that there is a genocidal plan, even if they don't have a specific intent themselves to commit genocide, so they can nevertheless be found culpable. And remember that genocide also is specifically criminalizes incitement. Yeah. So incitement to genocide is a very important tool. I defended a Rwandan cabinet minister in the Rwanda genocide tribunal. And one of the things he was charged with was incitement to genocide, which came from speeches. And there was a national radio station in Rwanda that referred to the Tutsis as cockroaches and to be exterminated. And so those are very powerful genocidal tools. And oftentimes people won't admit to a specific intent, and you have to look behind it. I mean, Eichmann never ever admitted to a specific intent for genocide, but it was plain from what he had done that he had actively supported the execution of a genocidal plan. So he was equally guilty. It's a very powerful concept, genocide, and I think, as I've said, one that needs to be perhaps looked at again to broaden the scope of it, changing things in either treaty law or customary international law is a slow process. But as I said, it's something that's under active academic consideration at the moment. And I think that the crime base, as it were, will be increased and expanded within the next 10 to 15 years, something of that nature. That's the sort of timescale that we look at.
That's incredibly informative. And Mr. Lewis, just before I turn to you, obviously we all recognise here that there are countries who are going to do everything they can to obfuscate, prevent prosecutions. How do you go about securing a declaration, particularly when that superpower is exercising every type of authority they have? Let's say it's an imaginative superpower, if we will. And then taking a step back from the ICC, the wider international framework for mass atrocity prevention, genocide prevention, whatever you want to call it, is that wider international framework fit for purpose? Or is there some kind of gap that the ICC would really love to see filled by a new organisation or structure or framework or a host of treaties that is somehow missing that you see every day in your work?
Well, as you know, you can't work in this institution without believing passionately that there needs to be some place of last recourse for victims, because you meet the victims in the places we work in, and I can tell you there is nothing more pitiable. And I mean that in the genuinely heartbreakingly pitiable, of people who feel that there's just no chance and no place that these cases can be dealt with. And I can assure you, despite what anybody thinks, there is when people talk about a thirst for justice, my goodness, there is a real thirst for it, and it's not something that goes away with time either. We're dealing with now with some of the cases of events that have happened a long time ago, and but they're raw for people now, and will always remain so. So I mean, so we're universal. You become a believer in the universality of these things, and now I can't help though that I was involved not in the Rome Statute, but immediately after it in helping create the laws of the court, the rules of procedure and evidence, more than 20 years ago now. And there was at that moment a particular feeling that was behind universality. People were talking about it, that it would be something that would happen, but it might take generations. It doesn't feel like that at the moment. I'm sorry, and I wish I'd love to be able to tell you that there was a great answer to it, but that's all I can do is say that the thirst for it is just as deep as ever. I'm sorry.
And if I can just chip in again, what really matters is publicising these things, putting it into the public domain of what's happened. I mean, we didn't know what was happening in Nazi Germany in the late 1930s and even into the 1940s until after the war. We didn't realise the extent of what had been going on. You can't hide those sort of things these days with social media and the instancy of communication. And as long as the instancy of communication is valid and proper communication, it's a force for real good. And I sometimes think when I read about people who are dismissive of international law, if they'd heard some of the testimony that I heard from victims or stared into as many mass graves as I have, they would think rather differently about it. And I endorse what Peter has said.
Thank you. I think what you're expressing there is the duty we all have to be a voice for those who others seek to silence. And I'd just like to briefly mention before we go to the next question, my gratitude to you both, because like you, I have met victims of genocide and appalling atrocities, and it will never leave you. So thank you for doing what I could never do, which is to deliver some form of justice for them. And I hope we're able to do that more in the future. So thank you for everything you two do.
Thank you.
Thank you. Neil, you wanted to come in for just the last thing, I think.
I did, and sorry, Chair, I wanted to come back to this filthy business of the horse trading that's already been touched on, and it's specifically this new prosecutor post, because it does look like a political process, and this has been touched on by both panels. It's less than opaque to outside observers. So I wonder if Ms. Lewis and Howe could give us their thoughts on why the UK candidate didn't go forward earlier this year, and next steps for that actually taking forward the appointment, and when someone new will be in post.
Well, the next stage of the process is taking place. I'm just looking up at the calendar of later this week, because there's now going to be a new round of interviews for the candidates who have been through the. There was a process of getting a smaller. There were obviously very many applicants. Then there was a group of about 14 who were looked at in more detail for consideration. Forgive me, I'm just giving you a factual account. I'm not seeking to defend this. This is a process that's done by state parties. So a group of 4 was put forward as being suitable for appointment. There were a series of then video interviews where they were interviewed by for questions from states parties and civil society, more deliberation then by the states, and there was some pressure to open up the list of candidates to be looked at for the full 14. So that process has been being discussed. It was agreed that it would be opened up. Not all of the 14 wanted to actually be involved in the process, continue to be involved in the process, but those who do are going to be subject to video interviews again this week. So the process will be all of them that want to be still going forward will be subject to this process of video interviews, and then that will lead to further debate and discussion amongst the states parties to try and find a consensus candidate. So the next stage of the process is later this week. And
it's underway. But the point that, and sorry to press a bit further, but one of the candidates put forward previously was ineligible under ICC rules. Is that not correct? Because it was a Canadian candidate. And I think what you're saying is that there was nothing wrong with our candidate. There was something wrong with the process. Is that it? Perhaps Sir Howard wants to come in, but it would also be good to hear how I'm a betting man. How do you rate our chances of being successful in this new round as things go forward this week?
Well, I've got to be honest. I'm sorry, sir, that there are some things, and it's one of the things I've learned from bitter experience that I am an official of the court, I'm an elected official of the court. I do not get involved in the elections of people. And I certainly couldn't get involved in any way, shape or form with a candidate from the UK. So for this is for the states parties to determine now. The UK is fully involved through its ambassador here in that process. So that's all I can really say for you, I'm afraid.
Yeah. Thank you. We do understand. So Howard?
I'm largely in the same position as Peter, but I mean, what we can say is that because of the expanded candidate list now, the British candidate who was not on the shortlist of 4 is now up for consideration, and like a lot of the other candidates, eminently qualified for the job. So I would say must stand on any merit-based appointment an equal chance. But I can't go beyond that. That's just a factual situation. If you look at the qualifications of all the candidates, some may be marginally more qualified than others, depending on your viewpoint. But the British candidate is now back in with a chance. But I can't say any more than that about it. It's an ASP election, and they will follow their procedures.
Thank you. I do appreciate the position you're in, but it is a different British candidate. But Chair, that's I think that's all from me. Thank you.
Thank you very much, Sir Howard and Mr. Lewis. Can I thank you both very much and echo Alicia's comments as well? We're both, I think the whole committee is enormously grateful for the work that the court does, and you as officers of the court do, certainly in standing up for so many human rights violations, or standing up against so many human rights violations around the world. Thank you very much indeed. And on that note, I'm going to close this afternoon session. Order, order.
The proceeding has ended.